My lord, I have some personal difficulty. It may kindly be taken at 2 p.m.
Okay.
All right.
Okay.
May I please, Lordships, I would like to mention item 37, my lord. In this case, matter may be adjourned for the day, my lord.
27. Okay. Both sides are represented. Or the prayer made by the counsel for the petition list after 2 weeks.
Obliged.
May I please, Your Lordship? Your Lordship, I beg to mention item number 32, Your Lordship. Your Lordship, Mr. Yanan Karmakar was leading advocate in this case, Your Lordship. He is no more, Your Lordship. So therefore, some time may be granted to obtain instruction from the petitioner, Your Lordship.
Both sides are represented. On the ground that the learned counsel holding the brief has expired. The matter stands adjourned today, list after 4 weeks.
Interim may be continued. There is interim. Your Lordship.
Entry is a bail. There's no
No, Your
requirement
Lordship.
of extension. Next.
May I please, Your Lordship? Your Lordship, back to mention item number 22, Your Lordship. Here in this matter, Mr. M. Ahmed is supposed to argue the matter, but he is not keeping well, Your Lordship. So matter may be adjourned for 3 weeks, Your Lordship.
Okay. After 3 weeks of the prayer, same order, 3 weeks.
I will believe.
Okay.
May it please, Your Lordship. Item number 19 may be adjourned for the day as my senior is out of station for some urgent matter.
Okay. After 2 weeks. 19.
Much obliged.
Lordship, let me mention item 43, Lordship. Counsel for petitioner, Mr. We are still not recovered, Lordship. So,
43 is a review petition.
yes, Lordship. Lordship kindly allows for passing over another 2 weeks, Lordship.
Okay, 43. Both sides are represented. On the ground that the learned counsel holding the brief is indisposed, the matter stands adjourned today, list after 2 weeks.
Much obliged, Lordship.
May I please, Your Lordship? I beg to mention item number 11, 18, and 34, Lordship. The engaged counsel out of station, Lordship. So, 34. Yes. Lordship, so kindly the matter adjourned for the day, Lordship.
18 of course.
11, 18, and 34.
11, 18, and
34, Lordship.
who is the lawyer who is out of station? There are 3 different sets of lawyers.
P. Rahman, Lordship.
In 11, P. Rahman is not there.
All different lordship.
18, he is there.
18 also P.
18 and 34, okay. 18 and 34, 2 weeks. Not 11, 11, this law is not there.
11 to Mata.
Obliged.
May I please, Your Lordship? Lordship, in item number 9, 1 day accommodation may be given, Lordship.
9. 9.
9.
Okay, list after a week, as after a week. Okay.
Obliged.
May it please, Your Lordship? Lordship, I beg to mention item number 33, Lordship.
Item
33, Lordship. Matter may be adjourned for the day, Lordship.
after a week. Yes.
With respect to item number 47 from the supplementary list, it's prayer for upgradation, if it may be taken.
Item 47.
Yes, for upgradation.
It will come. This is a motion matter. We'll take it up. If you're not upgrading it, we'll take it up.
Much of.
Daily list item 41 for orders.
May I please, Your Lordship? This case, Lordship, the review petition was filed against the order of the Supreme Court, Lordships. It was filed, review petition filed on 2021. But that review was listed on 14th or 20th. This court did not entertain since we have not filed any contention application. And hence, as per order of the Supreme Court, I filed this contention petition, Lordship. But actually, so far my knowledge is concerned, Lordship, in the writ petition, no contention is required review. That
No, you
is
have to
the
explain as a thumb rule, we take it only 30 days. So you have to
30 days,
explain.
Lordship, but yeah, that this honorable court directed
But
me to
14
file.
But
this.
14, no, it's right. Because you must explain something. 1435 days is how many years? How many years it will be?
And High Court's order is 3/7/2017.
No, you see, you are saying 1435 days.
1430.
In years, how many years it will be?
41.
18, 19, 20, 21.
Almost 5 years.
4 years,
Almost 5 years.
almost 5 years.
Then you must show good ground
Question
here.
is
We
that,
find nothing
Lordship,
here.
initial, my review petition was filed in the 2021, Lordships. It was filed on 2021. Then from the date of
2017 was the order.
12,
Past was
2017 was the
yeah,
order.
17 was the order. Then I approached the Honorable FS Court, Lordship. Then my application was withdrawn, special petition withdrawn with liberty.
What
to
is the
file.
date of the Supreme Court order?
Supreme Court's order dated, Lordship, 6/1/2020. That's I have annexed in my review petition, Lordship, page 46.
It will dismiss the withdrawal. Dismissed on withdrawal, na? Supreme
Dismiss,
Court?
yes, order.
Hmm.
Since withdrawn, naturally to be dismissed on withdrawal.
Reviewed লগাইছে আমার রিভিউ দিয়াই নাই 41 নাম হল তোমার আসিয়া খাতুন আই কোন গভর্নমেন্টের লইছে
You see, your ground in the review petition does not inspire any confidence. The reason is in the writ petition, we had examined the records and we arrived at a finding that Wakalatnama was filed on 10/3/2014. And after that, without any just cause, you did not appear. Now, in the review petition, your ground is that you have never issued any notice. That is the ground.
Lordships, in the review petition, Lordship, I am praying some more time may be given.
No. We are
To the-
discussing it.
At 2 p.m. take up, Lordship, but personal difficulty, I have not gone through the review petition, that's why, Lordship. At 2 p.m. or Lordship, day after tomorrow take up.
Lordship, already this
What?
I was filed in 23, Lordship, it's
My
listed only
lord
now.
is saying regarding review petition, I am praying for that regard review petition.
No, you see,
On day after tomorrow take up, Lordship, or tomorrow.
if we find any ground, we'll interfere.
Lordship, I will satisfy your Lordship.
1435 is something which is.
I will satisfy
Does
your
not
Lordship.
appear to be
Tomorrow
condonable.
or day after tomorrow, Lordship. In the review petition, Lordship. Is your Lordship convenience tomorrow or day after tomorrow, Lordship?
If you want to take an adjournment, please circulate in advance. We find it very difficult. We spend our personal time
Your Lordship,
Reading the brief and then in the morning when we ask one question, then you ask for an adjournment.
Lordship,
Till that,
I am,
no, no, you
I
see,
am under impression,
no,
Lordship.
no,
that conduct-
in the, when it started, you did not take for an adjournment.
Because I
But
am
when you ask questions,
un-
then you take an
under-
adjournment.
under impression, Lordship,
You don't
regarding
have the
confirmation
impression.
of delay, Lordship. I am sorry, Lordship.
No, no.
I'm sorry.
You
because
see,
I have not.
how
gone to
many,
this.
how many times in a day we have to tell you that in this, before this bench at least, motion matters are hearing matters, admission matters are hearing matters, orders matter are hearing matters.
Normally.
No, you
I
go to
have
the,
not
you go to
paid
your
for-
president of the bar association and you take his consent and give us a notice that all cases will be heard in hearing. No cases should be heard in the motion column or admission column
the-
or orders column. All matters should be heard. So we'll issue rule instead of motion.
Lordship, I am sorry. In this
No, no.
this case, normally
we ask-
normally I would not pray for
Once we
time,
ask
Lordship,
questions, then
every
taking an
question,
adjournment is something which is not appreciated.
I'm sorry, Lordship, sir.
Sorry doesn't
Personal
change things.
difficulty I have not go through. Normally, I every time Lordship prepared
List
and come
after-
with Lordship. I'm going to not praying for time, Lordship.
So, yeah, you see,
Today, my
let us do one thing. Be associated with me for the entire day, from morning till I go to my bed. And then tell us you experience our way of living. Experience with us the amount of reading we do.
at 2 p.m.
experience-
take up, Lordship. I am not.
It's okay, day after tomorrow, make it, but no adjournments. You want to take an adjournment, take it at 10:30. I don't mind.
Lordship.
But when you ask questions and then to take an adjournment is not appreciated at all. On a query of the court, both sides are represented. Huh? On the query of the court, the learned counsel for the petitioner prays for an adjournment. Prayer is allowed. List on 13/11/2024.
Oblige, Lordship.
42.
42
Senior counsel is out of station. May I request some accommodation?
time. But if it was sign a timeline, you might be able to mention this. The next, yeah. The next to 43 to mention.
Mrs. Verma,
Yes, Lordship.
the petitioner projects that he was under detention. And on release, this matter has been filed. There were some pecuniary difficulties, financial difficulties. The condonation of 53 days. Can we allow it?
Yes, Lordship.
But your name?
DK, my name is not in the wakalat.
It's okay.
DK Agarwala.
DK?
Agarwala.
DK Agarwal, learned counsel for the applicant. Who prays for an adjournment as the counselor record is not available. Next one. You have heard CGC is appearing. That's so.
M. Odhikari, Mr. M. Odhikari.
CG appearing for respondent number 1. This is A. Verma, done at standing counsel for the Home Department, representing respondent number 2. And 2, 7, and 8. Mr. A.I. Ali Leonard, standing counsel for respondent number 3. And Mr. R. Talukdar Leonard, government advocate appearing for respondent number 6. Next one.
45 to library.
We find that the foreigners tribunal number 2 is not a necessary party in the adjudication. And accordingly, the name of the form number 5 is performed. First of all, the registry shall do the necessary correction in the cost title without altering the seriatim of the parties.
Item of solution.
Next one. By this interlocutory application, the applicant has prayed for condoning the delay of 53 days beyond the period of limitation in filing the connected review petition. Next one. The learned standing counsel for the Home Department has opposed the prayer made in this application. Next one. However, on considering the projection that the applicant was taken into custody pursuant to the pursuant to the opinion dated 4/7/2016 passed by the learned member of a foreigners tribunal from Bongaigaon, Abhyapuri in case number capital B and GM oblique FT oblique case number
Yes.
3683 oblique 2008.
It one week.
And after 3 years of detention, he was released. And it is projected that the petitioner was under financial constraint for which the review could not be filed on time. Court is inclined to allow this application. Next, the delay of 53 days beyond the period of limitation in filing the corrected review petition stands allowed. Next one. There's the corrected review petition after a week.
Right.
45.
Met with your lordship. Lordship, we have filed this IA regarding extension of time, lordship.
What happened?
This honorable court, lordship, by order dated 29/4/2024, directed the petitioner to appear before the SPB on or before 22/5/2024, lordship. Lordship, page 5, para 3.
Please tell us. Please tell us what has happened.
Lordship, we did not have the contact number of the petitioner,
So
lordship.
you choose your words very carefully. You see, something out of place attracts our attention. Now, you have a mobile.
Lordship,
How many years you have been using it?
lordship, more than.
More than 10 years?
Yes, lordship.
More than 10 years. Has your mobile ever been out of order?
No, lordship.
No.
Lordship, they are the day laborer, lordship.
No, that's okay. But when you use your words, choose it very carefully.
Lordship, we did not have the contact number, lordship.
No, that's okay. But you gave a reason. You have read your paragraph 3.
Lordship.
Your mobile was out of order. This is something that doesn't happen. Either the mobile will die.
Lordship, Some people, they frequently change their contact number, lordship.
How many days delay?
Lordship, we have directly appear on or before 20 to 5, 2024, lordship.
Yes. No, 5, no, this is
And we have filed the IA on 26/6/2024, lordship.
27/6. Yes, Mrs. Verma.
What to say, Lord? This is the latest excuse now. And we will see it being repeating by most of the councils.
Okay, we don't want to disappoint her.
Lordship, that means the numbers which are provided in the petition do not match with the ones they hold. I come to this conclusion because once we have a Aadhaar card, we cannot go on changing our numbers. The OTP will always go back to the same number, Lordship. And now the plea cannot be taken that we do not have a Aadhaar card because these people are the first ones to have Aadhaar card and PAN cards.
This time you are sure the number given is correct number,
Lordship.
correct? 8011-930-932. You are sure?
Lordship, it was provided by Mr. H. Mubarak, Lordship. It was provided by Mr. H. Mubarak, Lordship, his advocate.
No, no, don't go by that. It will be very dangerous. You take it after some time. You just check in your true caller. If this is the number of
So check in your true caller.
Solimuddin,
The number of the client.
you have a true caller. You just check it up and then tell us. We'll take it up after some time.
Those, Lordship.
Supply item 49 for orders.
Paisa. The inspection was created.
Even the last time we are also directed to produce the instruction manual from the home department. There are both Ali and Arjun talking to one and same person.
Okay. Yes. That's it.
The effect of your signature.
Did it?
And Lordship, we just have one copy, Lordship. And it has it. আমার উপর ডিটেইলস তুমি বলবে নাকি ট্যাক্স কি আছে এটা
You file an affidavit then,
Yes, Lordship.
because if this is there, it will be very alarming. The police has given a report that both persons are the same person.
Then I may be allowed to reduce evidence.
He
before
has
the-
a.
Sorry.
Huh?
And then I may be allowed to reduce before the learned trial court, my lord. I will contest.
No, no, once we are taking cognizance of it, we'll take, we'll make, since we made an inquiry, we'll make it, bring it to a logical conclusion.
For sure.
You have an alias of Ajmat Ali,
Yes.
because if that be so, then your edifice of your case goes.
No, my lord, no notice
You
has been
can't-
served to me, my lord.
No, that's okay, but you understand the gravity.
For sure.
The police makes an inquiry and tells us that these are the alias of the same person. So if that be so, you take serious note of it.
And in this matter, my lord, no notice has been served to me, my lord.
No, that's
And the
okay.
record shows that, my lord, no notice
No,
has been
no.
served to me.
Once the report has come,
Lord.
in view of the order of the court, we'll
Lord.
bring it to Aussie Prudential. Then we'll go to the second issue.
Lord.
How much time is Verma? 10 days?
10 days, lordship. तुम्हें की खाली कॉपी करी है कि बोलेंगे अजी अजी 11 तारीख
Both sides are represented. Mrs. A. Verma, understanding counsel for the Home Department, has produced a copy of inquiry report. 8/11/2024 from the Superintendent of Police within bracket B, bracket close, Borpeta, indicating that Ajmal Haq, AJMAL, HAQUE, son of late Ajimuddin, AJIM, UDDIN, and Ajmat Ali, son of Azimuddin, AZIMUDDIN, same person.
Yes,
Full stop.
by order and
Instructions are perused and returned so as to enable the enable the authorities under the Home Department to file an affidavit in the matter. The affidavit shall be filed within 10 days, list after 2 weeks.
Okay, in the meantime, I may be allowed to go on bail, my lord. I am on detention.
No. Once if you are the same person, then we'll give a date then. Today is 11th.
Fix it up on 28 lordship.
You'll file by 20.
No, lordship, to do some difficulties.
Some difficulty lordship, 22nd.
After 25th lordship.
25th. To
25th.
file by affidavit to be filed by 25/11/2022.
After
24 list on 27/11/2024.
ठीक है sir.
27/11 list on.
Next paragraph. In view of the nature of objection raised, the prayer for bill stands adjourned and will be taken up on the next date of listing. Next list on 27/11/2024.
Marco, yes,
We are returning your instructions.
yes, lordship.
For motion, item 1.
Lordship, the impugned
Just a moment. Now you need to tell us why there is a delay of 4 or 5 years to approach this court by
Lordship,
filing the writ petition.
yes, Your Lordship.
What is the explanation?
Your Lordship, I have
They're
stated
coming
it,
after 5 years.
yes, Your Lordship. Lordship, I have stated in on page 24, para 29, Your Lordship. Your Lordship, though the order was passed on 27/6/2019, Your Lordship.
So because still, you see, your documents There's no document of medical you are showing that you are a chronic heart patient, you know, not file any document.
Yes, your lordship, I have not filed any documents, your lordship. If required, your lordship, I may.
No, I don't have any requirement. At
Your
least we don't have any requirement.
lordship,
It is your choice. You want to
Lordship.
bring it, you don't want to bring it. Because whenever it comes to medical issues, I always remember a politician of a very renowned politician from Bihar. He fights back. Whenever he's in jail, he's in hospital. Once he is released, he fights back.
Lordship, actually, your lordship, what happened, your lordship, during the pandemic, your lordship, there are several cases, your lordship, many clients, your lordship, lost contact. And these are, your lordship, laymen and women, your lordship, just sometimes lost contact with their advocates. And there are some lectures on the part of the advocates also, they also don't communicate, your lordship, at time. And sometimes, your lordship, due to some lack of communication, your lordship, just gets delayed. So thereafter, your lordship, after inquiries are made, your lordship, the certified copies are given to the clients, your lordship. So some delays that gets caused, your lordship. And your lordship, regarding heart disease, your lordship, few days back, your lordship, I got in touch with this client, your lordship, and she informed me she is in hospital, your lordship. So, your lordship, I should be able to produce some documents, your lordship.
Where is your sailed it out 1932? Where is that document? Which page?
Page 30, 32.
Huh?
30 to 32.
32.
First, third, it starts from page 30. The type copy, your lordship. And 31 and 52.
He was exhibited. 17.
Lordship. Sorry.
You're not on the computer. You just accept it, yes. Jama. No, opinion of the same, 6. Need 78 to mention Kosa.
Your Lordship will find it on page 74 to 78. It's evidence of an affidavit, Your Lordship. 74 to 78.
I don't think you've annexed it.
Hmm?
No, you have not annexed it. Page 47, Swastika.
Possibly done that.
47. 47 to 51.
Your Lordship, I couldn't annex it, Your Lordship. That was not given to me, Your Lordship. But Your Lordship, it has been reflected in the order, Your Lordship, that the contention of DW2, that is on page 87, Your Lordship. The brother of the proceedee adduced evidence by way of wherein he more or less supported the proceedee. The brothers exhibiting a voter identity card. So, Your Lordship, the brother of the petitioner also came forward and Your Lordship adduced evidence by way of affidavit, Your Lordship. Mr. Lordship, that was not provided to me, Your Lordship. Your Lordship. Your Lordship, in this case, Your Lordship. Your Lordship may submit, Your Lordship may submit a few lines, Your Lordship. Your Lordship, in this case, Your Lordship, the matter has been, your lordship, discarded all the evidence on the ground that the pre-1971 documents were not proved. Now, your lordship, the voter list of 1966 and 71, where my father's names are there. Now, Lane Tribunal says that in spite of my same village, same moja and everything, why my LSE is different? So the legislative constituency name is different. In 1966, it was Balipara. In 1971, it is Rangapara. The learned tribunal ought to have applied its judicious mind, your lordship, because on today there is no constituency called Balipara. The same Balipara constituency was delimited and it got became Rangapara, your lordship. Your lordship will find it.
Delimitation to establish 19 Lordship, delimitation
Your lordship,
process
exhibit
was
C.
just 2 years back.
Your
This
lordship.
opinion is of 2019.
Your lordship, delimitation took place in 1970, your lordship. The earlier delimitation. That was the earlier delimitation, your lordship, 1970s.
Lordship will have to examine the matter.
Your lordship will say exhibit C.
Call
Your lordship,
lordship.
exhibit C, your lordship. Page 85, your lordship. Yes, sir, exhibit C. Exhibit C is the voter list of 1966 of 78 Balipara LSE of village Samdhara Moja, Goroimari, subdivision Teshpur, wherein the name of Abdul Motleb, son of Moniruddin, aged 42 years, is reflected. This is computer generated copy. And exhibit D is the another voter list of 1971 of 74 Rangapara LSC of village Samdhara, Moja Goroimari, wherein Abdul Motleb, son of Moniruddin, aged 42 was reflected. Now, your lordship, the learned tribunal again says it is strange that in the voter list of 1906 of Abdul Motaleb age is 42 years and the age in the voter list of 1971 same 42 years. Secondly, in the voter list of 1966, the Abdul Motaleb is enrolled in the 78 Balipara LSC, but Abdul Motaleb in 71 voter list is 74 Rangapara LSC is reflected. Two different LSCs of the same person is not believable, and the proceeding has also not explained why the constituency changed from 78 Balipara LSC to 74 Rangapara LSC. Therefore, it cannot be established that Abdul Motaleb of 78 Balipara LSC in 1966 voter list and Abdul Motleb of 71 voter list is the same person. Therefore, both the voter lists cannot be accepted for determining the Indian citizenship. Your lordship, it is a known fact to all, your lordship. Today in Assam, we don't have an LSC named Balipara. The place Balipara is within Rangapara constituency today.
Yep, that's been my commitment.
Person, page
Page 40.
20. Seventy-one, 71 or 43.
It's a 42.
66 no Baba. 70, 43.
40.
And your lordship, the learned, the procedure, your lordship, the petitioner also has exhibited her HSLC admit card, your lordship. That is on page 66, your lordship. Before that, your lordship, I'd like to take your lordship to page 39, page 40, which is the voter list of 1966. Page 39, 40. Your lordship, if your lordship compare it with the voter list of 2010 and 2015, your lordship will find that the DW2's name is in the voter list of 2010 along with the person Abdul Mutlef, whose name appeared in the voter list of 1966 and 71. And if your lordship peruse the lordship, voter list of 2010, your lordship, or sit, your lordship will see the voter list of 2010, your lordship, on page 58, 59. 59, your lordship, Abdul Mutlef, late Moniruddin, is 76. From the same village, same moja, now Rangapara LSC of 1971.
You see, any voter list prior to 2010 showing the procedure and the brother together?
Your lordship, 2015. Your lordship,
No.
along with my, not just my brother, my father's name is also there, your lordship, 2015.
No, prior to 2005, prior to 2007.
Prior to 2007.
What is the document showing you with your projected parents or grandparents?
Your lordship, my admit card, your lordship, in my admit card, your lordship, my name is shown along with my father's name, your lordship.
Which page?
Page 66, your lordship.
Page 66.
Lordship. My date of birth
We can accommodate you by listing it day after tomorrow. You show your medical documents if you have. Because otherwise, we are not inclined to grant.
Your lordship, then I may give in another week time, your lordship. I have to get in.
Lordship, in the meanwhile, records may be called for lordship.
Mr. Am I Hussain, counsel for the
Your lordship,
petitioner?
I Hussain. MD I Hussain.
Mohammed I.
Hussain.
Oh, yes. What I Hussain, counsel for the petitioner. Praise for some time to obtain instructions on the health condition of the petitioner. All the respondents are represented. Next para. In the meanwhile, let the records of case number FTDC full stop 319/16 corresponding to ref okay. First line to obtain instructions on given condition and to file affidavit if so advised. Next part, list in the motion column. After
Which it will take at least 4 weeks for the record to come, your lordship.
okay,
Sorry, put that away.
list from 9/12/2024.
Our lordship list after receipt of LCR,
No, since we are not giving him bail, we're giving a
Nine.
fixed date.
9/12 lordship.
Your lordship, then your lordship, can it be in the last week of November, your lordship? Because
Okay, 29/11.
like,
Time being item 45.
I'm extremely sorry, Lordship. The contact number which the petitioner has provided, it belongs to Mr. H. Mubarak, Lordship. He was earlier in our chamber, Lordship, and thereafter he is now practicing at Gongai.
We adjourn the matter. We are not saying anything to you. You understand the gravity.
Then Lordship may allow me to file an additional affidavit where I will provide the correct.
We'll just adjourn it.
Lordship.
We'll just adjourn it. We are not making anything on record. This is item number
45, Lordship.
45. It's on the chair made by Ms. S. Das and counsel for the applicant. Matter stands adjourned today. You say first both sides are represented. List when?
Lordship, after a week, Lordship.
List after a week as prayed for.
I'm extremely sorry, Lordship.
It's okay. But
Obliged, Lordship.
Item 2.
May I please, sir? Lordship, improved order at page 23, Lord. Order dated 19/6/24. Page 23. 23.
what is the best document to connect you to your projected parents?
Page 42.
Page
42.
42.
Serial number 74. Lordship, in the voter list of 1966, my father name is not there. My grandfather name was Azim Asaruddin, serial number 74.
Any document to connect to your
Now,
parents?
Lordship, kindly see page 70, page 46, Lord.
46.
46. In 46, Lordship, serial number 429, Lordship, Azimuddin was my father. And Moizuddin, Lordship, the serial number 430, Moizuddin was examined as Lordship, DW4, Lordship. Lordship, in the same voter list, Lordship, 1977, Mesaruddin name was also recorded, Lordship. But that documents was not exhibited before the learned trial court, Lordship. That is page 49, Lordship. Maybe sin, Lordship.
No, is there any document to show that who is your father? Any document?
No, there is, oh, Lordship. This is Panchayat certificate, there, Lordship.
Which
That
page?
is duly exhibited, page 102. And secretary was duly examined, Lordship. Oh, sorry, Lordship. That is 100. And secretary was examined, that is page 105, Lordship, annexer 19.
Page number?
105, Lordship. This is cross-examination part of the.
It doesn't help you because of the cross-examination. Read the cross-examination.
Yes, Lordship.
There's no personal inquiry. He's a
Certificate is, Lordship, 102, Lordship.
he's a Kaha Panchayat
Yes, Lordship.
secretary since 2021. There's
Lordship,
no personal
DW,
knowledge.
Lordship, DW for Moizuddin Ahmed, Lordship, Moizuddin, Lordship, who had casted vote along with the father of the petitioner in the year 1977, who deposed before the tribunal and he duly, Lordship, admitted that petitioner is his niece, Lordship. That is page 98, Lordship. Evidence of the
Who is he?
pattern
Who is he?
98.
He's not a member of your family.
98. Lordship.
He's not a member of your family.
Lordship, young, that is, Lordship, brother of my father, Lordship. In the year 1977, Lordship, DW4 and the name of the petitioner's father duly recorded from the same house number,
But-
Lordship. No, Lordship, he mentioned, Lordship, I have 13 siblings. He mentioned, Lordship, in the fourth line, I have
That's okay.
13 siblings. He mentioned all the names, Lordship.
First line is that I don't know. When she took birth, I don't know. I don't know how
No,
many
Lordship,
siblings had my father.
when she took birth, Lordship, I don't know. This is in respect of the petitioner, Lordship.
No, no,
I don't know
fathers-
how many siblings had of my
fathers-
father.
Huh?
His
So
father,
uncles and all, he doesn't know anyone.
But in the voter list of 1977, Lordship, their names duly recorded along with the father of, along with the Mesaruddin also. In the 77 voter list, petitioner's father, grandfather, and petitioner's uncle, Lordship, DW4 recorded, duly recorded. Lordship, at this stage, notice may be issued and may be given, Lordship. Let record may be called for. Lordship.
heard Mr. A.T. Sarkar, learned counsel for the petitioner. Also heard Mr. M. Adhikari, learned CGC appearing for respondent number 1. Mr. G. Sharma, learned standing counsel for the Home Department. Mr. Puli, learned counsel appearing on behalf of Mr. A.I. alias, standing counsel for the respondent number 3. Mr. Sharma would be for number 2. Two, 6, and 8. And Mr. R. Talukdar, learned government advocate, appearing for respondent number 5 and 7. Opinion is page 23. Opinion dated so and so, passed by so and so. Is said in this petition filed under Article 226 of the Constitution of India. If you notice, returnable in 4 weeks. Requisite extra copies of the petition be served on London State and Departmental CGCs, State and Departmental Council within 2 days. Let the relevant records be called from the consent tribunal. Bail of rupees 5,000. Pay before the SP border.
Dhubri lordship, respondent number 6.
Dhubri within 10 days and take bail rupees 5,000. Next paragraph. Oh no. No, we'll have to adjourn the matter. You have not disclosed your phone number in the affidavit.
Lordship, we have mentioned lordship.
No. At least in the copy which I have, it's not there. Look at page 22. It is not there.
I am just lordship. I am only allow me to by hand lordship to me.
Affidavit will not allow you to make any tampering. You'll have to file a fresh affidavit. Nothing can be added or subtracted from an affidavit. You just see, be satisfied.
Sir, read to better perhaps lordship. This is in my office copy. This is duly.
That's okay. But in
Kindly
my
allow
copy,
me
you
to
don't
by
have-
hand lordship.
No, affidavits, we can't allow you to touch it. You know the law. Okay. You just said both sides are represented. The affidavit filed by the petitioner in support of the petition does not contain the telephone number of the petitioner, which is mandatorily required. So accordingly, matter stands adjourned today. Next, liberty is granted to the petitioner to file a fresh affidavit and to disclose the mobile number, personal mobile number, or any mobile number through which she can be contacted in terms of the High Court notification. Next paragraph. Place the matter on
Friday.
So you will be able to file the affidavit by then.
Lordship.
Vacation,
This Friday.
this Friday vacation.
Oh, it's a holiday.
Yes.
Oh, okay.
The Thursday.
18/11/2020.
Item 3.
May I please, your lordship?
Yes. What is the date of the opinion?
Opinion that 13/5/24, Lordship. Page
What is
number
what is the
49.
best document you have?
Page document, Lordship, voter list of 1985, annexure 9, page number 89.
No, apart from voter list, any other document?
Gabra certificate, Lordship. Page number 84.
84.
Yes. মাত্র dollar only না। আমাদের বাপে একটা মানে নতুন চেক হয় না।
Page number 79 is missing from our copy, Lordship. Page number 79 is missing from our copy.
Page 79 is missing, Lord. Page number 79 is missing from our copy at least, Lord.
ওটাকে দেওয়া আছে এখন প্রথমটাই দিচ্ছি।
No, no, give them a copy. Nobody has them.
Oh, very good. Second, no?
Okay. You supply copy, but
আচ্ছা, I have already given.
okay.
42, sir. Point number 42.
Their copy was not corrected. Perhaps you served to me, Lordship, but some wrong file has come. Lordship. Okay.
Okay, you don't have a case, but you are giving a bail. You've not been able to show anything. Your witnesses have not been able to establish your case.
Actually, my cousin
Your cousin's evidence, you look at it, has got nothing. Okay, heard Ms. T. Begum, learned counsel for the petitioner. Mr. M. Adhikari, learned CC appearing for respondent number 1. Mr. G. Sharma, learned standing counsel for the Home Department representing respondent number 2 and 4. As well as Mr. R. Talukdar, learned government advocate appearing for respondent number 3. And Mr. H. Miss
S.T. Khan, Your Lordship.
S.T. Khan, learned counsel appearing on behalf of Ms. P. Barwa, standing counsel for respondent number 5. Which page is the opinion?
13, Lordship, page number 49. Dated 13/5/2024. Page number 49.
Page 49, opinion dated 13/5/2024. Asked by so and so and so. Is assailed in this writ petition filed under Article 226 of the Constitution of India. Notice steps. Sorry, extra copies within 2 days. Appear before the SP border, Barpeta, within 10 days and take bail of rupees 5,000. Conditions. Call for the records. Same. List up to 4 weeks on receipt of records.
I'm deeply obliged.
Item 4.
10 days time to take bail.
May please your lordship.
Yes, Mr. Siddharth.
My lord, we are against the ex-parte order, my lord. But you will
Ex-parte.
kindly have a look at the case 21 ex-parte order dated 5/9/2022. Lordship, the relevant portion is at paragraph 2 of the judgment at page 22. How the notice was served.
Yes,
May I read out, my lord?
yes, yes.
Accordingly, after registration of the case, notice was issued to the OP to appear and to file detailed statement and to produce evidence in support of his citizenship. After service, notice returned with service report. On perusal of the service report, it is found that in person to the notice, the process server went to the address mentioned in the notice, and after inquiring the local village people, came to know that the OP had left the aforesaid village and went to some other place by changing his place of residence without intimation to the investigating agency. The process server, in spite of diligent search, and could not locate or find the last resident of OP, as he had left the village, and under the said circumstances, having no other alternative, affixed pasted a copy of the notice on the office of the Gaura in presence of witnesses Aminul Haq Gaura, village Romari Pathar, so on so on. So, my lord, even the, my lord, notice is not validly served. It should be outer door of the proceeding, and she is all along. He is all along in her place, my lord. The brutalist itself disclosed that he never shift the residence, my lord. So absolutely, so report is false, my lord.
Process server report আছে নেকি?
রিপোর্টটা আমি অ্যানেক্স করা নাই, জাজমেন্ট তো এভরিথিং আছে,
হ্যাঁ
জাজমেন্ট ইজ সাফিসিয়েন্ট। অর্ডারও তো লেখা আছে, the 22 সব প্যারাগ্রাফ গাগরের ভবিষ্যৎ লাগাইতে প্রভিশন মতে আফটার ডোর অফ দি প্রসিডিং এমনি একটা রিপোর্টের নির্মাণ করে দিও, কন্টেক্ট করে দিও, ডকুমেন্টস তার আছে।
Yes, Mr. Sharma. Mr. Sharma, do we call for the records or we demand the matter at motion stage?
নির্মাণ করে দিও,
I leave it to your lordship.
Do you tell us, because we also need your input.
Yes, lordship, let him contest the case, lordship.
Huh?
Let him contest the case, lordship.
by remaining.
Heard Mr. A.R. Sigdar and counsel for the petitioner also heard Mr. M. Adhikari Leonard, CGC appearing for respondent number 1, Mr. G. Sharma Leonard, standing counsel for the Home Department, representing respondent numbers 2 and 5. And Mr. Kuli Leonard, counsel appearing on behalf of Mr. A.I. Ali, standing counsel for respondent number 3. And Mr. R. Talukdar and the government advocate appearing for respondent number 4. Which although respondent number 6 is an establishment under the Home Department, but neither the government advocate nor the standing counsel for the Home Department has instructions to appear for them. Therefore, no appears on call for respondent number 6. Next one. The ex-parte opinion dated 9/5/2022 asked by the learned member Foreigners Tribunal 7th from Borpeta in case number FT 451 of 2019 corresponding to reference case number 655/04 is a sale in this petition filed under Article 226 of the Constitution of India, inter alia, on the ground that the notice was not served upon the petitioner in accordance with para 3 within bracket 5 within bracket F small f of the foreigners tribunal for the foreigners within bracket tribunals bracket close order, 1964. There is no apostrophe here. By the said opinion, the petitioner was declared to be a foreigner of post 25/3/1971 stream. Next para. The learned counsel for the petitioner has submitted that the legal requirement of para 3 within bracket 5 within bracket small f of the foreigners within bracket tribunals bracket close order, 1964 is that if the proceeding has changed the place of residence without intimation to the investigating agency, the process should be served on the outer door, should be affixed on the outer door or some other conspicuous part of the house where the proceeding last resided. It is submitted that the voters list appended to this writ petition discloses that the petitioner has not changed his address and he is still available in village. Romari, Roumari, Pathar, PS Tarabari in the district of Borpeta. It is submitted that the petitioner has sufficient documents to prove that he is not a foreigner. Next paragraph. The learned standing counsel for the Home Department has made his submissions to support the ex-parte opinion dated 9/5/2022. It is submitted that as the petitioner was found absent, notice was affixed in the office of the Gambura in the presence of witnesses. Next para, we have considered the submissions of both sides and also peruse the provisions of section 3 within bracket 5 within bracket 4 1964 order. The said paragraph is quoted below. Only 3F, 35F. Next paragraph. Accordingly, we note that the requirement of law for service of process under para 3 within bracket 5 within bracket small f is to affix the process on the door or other conspicuous part of the house where the petitioner last resided, proceeding last resided. The said procedure was not followed. Therefore, we find that the continuation of proceedings against the petitioner on the strength of the process service report as referred to in paragraph 2 of the impugned opinion cannot be sustained. So accordingly, from the ex-parte opinion dated 9/5/2022, is found to be vitiated on account of service of notice which is not envisaged under the foreigners tribunals within bracket the foreigners within bracket tribunals, it was ordered, 1964, specifically para 3 within bracket 5 within bracket F thereof. Next para, accordingly, the court has no hesitation to set aside the said ex parte opinion dated 9/5/2022, passed by so and so and so and so. Next para. The said opinion is conditionally set aside with the direction to the petitioner to appear before the foreigners, before the learned member from a foreigners tribunal number 7th, Barpeta, within 29/11/2024, and by producing a certified copy of this order, seek further instructions from the said learned tribunal you'll file your written statement also on that day,
My lord. Lord, we'll try to file on the same day. There may be some insufficiency of documents and all.
Reference is of 2004 lordship.
yes.
Yeah.
So on appearance, the learned tribunal will afford
getting
sufficient
sufficient
opportunity
time,
to the
Lordship.
petitioner to file written statement and documents. In terms of the said 1964 order. Next para. In the meantime, the petitioner is also directed to appear before the Superintendent of Police within bracket border, Barpeta, within 10 days from the date of the order, and on furnishing of a bail bond of rupees 5,000, will be allowed to remain on bail. The same with the conditions. So it is made clear that in the event the petitioner does not appear within the time allowed before the Superintendent of Police within bracket border, Barpeta, the order of bail shall stand revoked without any reference to the court. Next para. The learned standing counsel for the Home Department shall also transmit a copy of order of this court to the Superintendent of Police, Barpeta, border Barpeta. Representation stands allowed in the motion stage without issuance of notice on the respondents.
Deeply obliged.
মানে মই কৈ দিছো মেইনত মেইন এই আপুনি পাতিল ওকে ওকে পাতিল হেৰি মনচিক যে এটা ফাইল গৈছে WBC 4806 সেইটোকে দি দিব পাৰে জাজমেন্ট আছে WBC 4806 এই মাত্ৰ যোৱা সেইটো ফাইলে কৈছো চাই লোৱা কাইদৰে তোমাক হ'ব নে নাই এতিয়া যোৱা বাৰু চাই ল'বা এতিয়া আইটেম নম্বৰ 5 টো দি দিছো ছাৰহঁতক সজাই থৈ দিছো আহিলে 5 বুলি মাতিম অৰ্ডাৰ্ছ খিনি মানে আয়ে থকা কেইটা গৈছে আৰু আজি তোমালোক 3 জন ন আজি সুগ্ৰীব আজিৰ পৰা আহিছে আৰু ষ্ট্ৰেংথটো বাঢ়িব আৰু ক'ত যাব তাই আমিজনী এতিয়ালৈকে ঠিকে আছে বাৰু কাম চাম পেলাই থব মিলিছে আৰু ফটাফট কৰি আছে অং নাই আৰু নৰ্মেল আছে এইখিনিতে ঘৰ এটা সেইদিনা ওলাই যোৱা মোক দেখা পাইছে মই খোজকাঢ়ি যোৱা মোক কৈছিলে এইখিনিতে ঘৰ এটা চাব নেকি মই চাইছো মানে এতিয়া সিহঁতে পাব মানে ইহঁতৰ বাইক আছে যেতিয়া এখন মানে নেপালী চত্ৰ থাকিলে কিন্তু এটা 10,000 টকা বুলি কৈছে 10-12 বহুত বঢ়িয়া ঘৰ পাব কিন্তু উজান বজাৰ থাকিবলৈ খুব ভাল 10-12 হাজাৰ মানে 2টা ৰুম পাব আৰু যেনে তেনে চাগে মই এজন দুজনক কৈছো ঘৰ পোৱা অলপ মানে ঠিকেই
হয় হয় ঠিকেই সেইটো হয় তুমি ভাল কথাই কৈছা সেইটো নহয় আৰু ৱাষ্টেজ অফ টাইম হয় নে নহয় এতিয়া তাইৰ কাৰণে
May be lost. Second time litigation will earlier remanded back the matter and subsequently also declared petition as a final matter. Here is a linkage documents is space voter list of 1997 and DW2 elder brother whose name appear along with the parents in voter list of 1989. Voter list of 1997 page 60 Miller. Delay Miller para 25. Yes. 30/11/2023. He is a professional driver, man. He is outside and he at present out of driving Miller. That's why some problem arise, Miller, and it's also problem. Miller. Opinion is page 94.
Your brother did not bring any proof of his.
Discarded Miller. All the documents Miller evidence also discarded Miller. Only on the ground dates Miller. A petitioner original place of birth is Nimua. In 2000 shifted to village Bungshibari Miller. He has submitted
not only
subsequent
that,
voter list
because
and earlier voter list.
everywhere there's a, in each and everything, there's an opinion of the tribunal. Your voters list, your age was 13. If your age is to be believed,
Yes, age
then
is
in
discrepancy.
97, you were 13 years.
Yes, age is discrepancies. Miller. Voter list are not prepared by the petitioner side Miller. There's officially Miller. And
that you already have
normally
judgment.
Miller enumerator not visited the house, each house Miller.
For that,
They
you
are
already have judgments.
Yes, Miller. Otherwise, Miller petitioner established linkage Miller with the parents Miller in Nimua village Miller, place of birth. And subsequent voter list also submitted Miller. And a tribunal appointed that Miller, 2 sets of documents, 2 sets of voter lists produced from different villages. In the written statement as well as evidence, Miller, it has stated the shifting part Miller. And High Court's order Miller, page 90, para 5 Miller, can list it. Finding. Contested. Para 4 and para 5. Voter list of 1971 and 89 Miller. House number is same Miller. Father, mother, petitioner, elder brother, all our name is.
Where is the previous order of the High Court?
High Court order is page start from 88 and that page 90, para 4 and 5. 4, 5, 6.
88.
Start from 88. Finding part is page 19.
You see, let's say we record this. We come to paragraph 6 of the earlier order at page 90. The matter was remanded only to examine as to whether the voters list established yourself to be the citizen of India. So that was the only point. And this point was decided by the tribunal.
On other ways, Miller. Other ways means, Miller, petitioner submitted two sets of documents, Miller. One is shifting part, one is the place of birth, Miller.
No.
And place
Please-
of birth, he has a linkage established.
Please interpret paragraph 6. That is the only, you see, you gave evidence earlier. The court now says that you give an opportunity to prove that you are the voters, your voter will prove your citizenship.
I kindly see para 5, Miller, page 90, Miller, High Court order. And the last one, the last 4 line, Miller. The contents of the aforesaid voter list 85, 89, 97 of village Nimua, Moja Govardhana, prima facie show a linkage of the petitioner with date of initially. Although shown as initially whose name appear in the voter list of 1971 of the same village. Kindly see para 4. Thank you. Before the tribunal, the petitioner exhibit voter list of 1971 of Nimua, village Nimua, Moja Govardhana, serial number contains the name of Nunu Sali, son of Kalu, and serial number 655 shows the name of Aziranasa, wife of Inus Miller. It is stated that Inus wrongly has been recorded Inus, and it can be wholly disregard the Inasmas as the Aziranasa serial number shown is shown as the wife of Inus, so and so both of them reside in the same village, house number. And voter list of 1989, same house number, Miller, 134.
In the present opinion, which is impugned, your citizenship was not rejected because of that. But the court,
So many grounds, Miller. I said discrepancies of age and name, and Miller. No document prior to 71. Cut-off date is, my lord, say, 25th 3 1971. No documents prior to 1970. Linkage established fail. Miller, public government, and so many judgment is put it in this case, Miller. Long judgment. Yeah, nobody raised any objection regarding the voter list, Miller.
Not regret, Lord.
Any evidence also, Miller.
Mr. Ahmed, those arguments doesn't take us anywhere. If there's an ex-parte, have you not found any ex-parte decree where the suit was dismissed?
And learned tribunal finding is page 104, Miller, para 35. Under the facts and circumstances and discussed above, I do not find any reason to take a different view. With a view with regard to the citizenship status of the OP had already been decided. And that means, Miller, the tribunal is predetermined.
No, Lordship, there is nothing, Lordship. In this case.
I do not find any reason to take a different view. Different view which means, Miller, earlier he is a decided, Miller.
No,
A
correct, that
predetermined,
decision
Miller.
is already there.
Yeah.
Where is the, you see, because you see the in this High Court judgment at page 88, the earlier opinion was not set aside.
Yes. Yes, not set aside.
Then what is wrong in the tribunal taking the same view?
1971 voter list is totally different from other voter list, Lordship.
No, 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 no. 71 voter list, here is Azironnesa mother.
And
Okay, let us call for the records to examine it.
yes, Lordship. But everywhere discrepancy, Lordship.
Huh?
Each and every document there is a discrepancy, Lordship.
Yes. But Mr. A.M. Ahmed will copy for the petitioner.
মোর নামতে discrepancy? আমার নাম না।
Also heard Mr. M. Adhikari and
Huh?
CC appearing for respondent number 1. Mr. G. Sharma and standing counsel for the Home Department representing respondent number 1 and 6. Mr. R. K. Mr. R. Tarukdar and government advocate appearing for respondent number 3. And Ms. P. Barwa and standing counsel for respondent number 4. Page 94 opinion. Opinion response was assailed in this repression. Notice call for the records. Appear before the Superintendent of Police border Baksa within 10 days and take bail rupees 5,000. On failure to appear, the order of bail shall stand revoked.
Ito. It's on Friday. No. Mm.
Just after 4 weeks on receipt of records.
No.
Complex.
Item 7.
May I please, your lordship?
2021 ex-parte opinion.
Yes, lordship. Opinion at page 42, lordship.
Where is the opinion?
At page 42,
42.
lordship.
Thank
But then there's no ground why you did not appear.
Kindly see, the proceeding was held during peak COVID-19 situation, lordship.
Pardon me?
During the peak COVID-19 situation, lordship, the proceeding was held. Lordship, may kindly see, the petitioner appeared on the first occasion after receipt of notice on 24/2, lordship, 24/2/2020. Next date was fixed in the month of March 2020. And
No, you see,
thereafter,
those are, that is okay.
yes, lordship.
But even after that, when there was no COVID, you have no explanation.
During that period, the case was decided, lordship.
It's okay, but after that, you also never challenged it. So you accepted that
Yes,
opinion.
lordship, there is delay, lordship. I have stated the poor condition, and in the meantime, her husband also died, lordship. So there are some problems he faced, lordship, at that time. Mentioned.
There's no explanation at all here also. Where have you described?
Lordship, I have stated, Lordship, ground of delay, there are 13, 12 and 13, Lordship.
It is
That-
not an explanation.
12 and 13, and Lordship, her
Para
husband.
12, para 12 cannot be accepted. You say that he was neither informed. So who would inform?
Yes, he literally lady, Lordship.
It's
and,
okay, but you see, in a
Her husband.
nowadays we have so many things. Let us say, for an example, we have this UPI payment systems or mobile bill paying system where you can pay in advance in the wallet. And from there it will be deducted. Correct? Now in the tribunal did you have some funds? Give some funds that after the order notice will go to you.
Her husband also died during that period, Lordship. That was.
Because
also-
in our knowledge, we have never passed an order and then said that communicate. We communicated to the SP border for a different reason.
Poverty I have mentioned in page 30, paragraph 13, Lordship. And this is due to the death of her husband, Lordship. During COVID situation. Sons may be given. I have all other, otherwise, Lordship, I have all other documents. From my, even from my grandparents, Lordship, 66, from 1966. All other documents are there. In 51 NRC, my father's name appears, 66 voter list and 70 voter list, my grandparents and parents' name. Then 75 also grandparents and parents' name, 1985, 89 parents' name, Lordship. Thereafter, my name appears along with my husband, Lordship. And
So therefore, there is no document to connect you to your parents.
yes, Lordship, Gavura certificate I have annexed here, but that can be proved only when the case is contested, Lordship. That document I have annexed, Lordship, page 40.
This court.
Lordship,
September 2024, Lordship, it was collected, Lordship.
yes, this will be proved by
Initially,
the,
reference was initiated in the year of 2001, Lordship.
by the issuing authority, authority, it may be proved, Lordship, if the hearing is commenced, Lordship. That opportunity may kindly be given, Lordship. All documents or credentials are there, Lordship.
Okay, we'll give you a 2 weeks notice. We'll take it up on the after 2 weeks. In the meantime, your prayer for bail will be considered after 2 weeks.
Lordship, police is behind me, Lordship, that may be considered. I may be protected, Lordship. My prayer,
No,
Sorry, Lordship.
21, you have not shown any good cause.
good cause, Lordship, due to death of her husband, Lordship, that was a big problem for her, Lordship. And poverty is there, your Lordship may kindly appreciate these people are illiterate person. Husband is dead, Lordship. These things may kindly be considered, Lordship.
Ninety-one.
21 or
No, for 2 weeks, you'll have to manage somehow. But Mr. M.I. Hussain, learned counsel for the petitioner. Also heard Mr. M. Adhikari, learned CGC appearing for respondent number 1. Mr. G. Sharma, learned standing counsel for the Home Department, representing respondent number 2 and 2, 6, and 7. And Ms. P. Barwa, learned standing counsel for respondent number 3. And Mr. R. Talukdar, learned government advocate appearing for respondent number 4. 5. There is no representation from respondent number 4. Next, by the opinion is page 42. The ex-parte opinion dated so and so, passed by so and so in so and so, is sealed by the petitioner under Article 226 of the Constitution of India. Next paragraph, the counsel for the petitioner has submitted that due to poverty and death of her husband, the petitioner could not challenge the said opinion, ex-parte opinion, within the time allowed, within a reasonable time. Moreover, it is submitted that the proceedings before the learned tribunal was initiated and decided within the COVID-19 pandemic period. Next paragraph. Letter of notice returnable on 18/11, no, 22/11/2024 be issued. Requisite extra copies of the writ petition be served on the learned CGC, state and learned departmental counsel within in course of the day. Next paragraph, list on 22/11/2024, when the prayer for interim relief shall also be considered.
Obliged.
8.
Yes, yes.
Maybe.
No interim. This is a deep.
This is a voter, go to single bench.
Yes, Lord.
Of course, earlier similar cases were listed with similar, and this one case was decided in individual branch. Difference is there.
No.
Right.
These are the single bench matters. The both sides are represented. The tag of D voter against the petitioner in the voter list of 2011 is sealed in this writ petition. Next part, the Mr. G. Sharma and the government standing counsel for the Home Department has submitted that this matter can be taken up before the learned single judge, as the petitioner is not challenging any opinion of the foreigners tribunal. Next part. The registry shall examine and list the matter before the appropriate single bench. In the motion column.
And maybe on Monday,
It will go immediately. We'll release it today only.
No.
Item 10.
Legal lordship. My lord, this is a contested case.
What is your explanation for 2 years?
My lord, paragraph 24.
24.
24. Yes, page 27,
Financial hardship.
financial hardship. All
And
these
what is your
people
good document?
are, documents, my lord, there is a land documents of the grandfather at page 46, translated copy vernacular at my lord, 47, grandfather's name. Then my lord, 70 voter list, both parents, grandfathers.
No, just
and
first the land documents first.
my lord,
Where is that?
land documents at page 46, translated copy, vernacular at page, next page, my lord. Turapali, my lord, Turapali. Turapali Pathan, my lord. In some documents Turapali, some documents Turapali Pathan, my lord. This type of variation is there. This is of Sita of 1958-59 of village Moiraja.
Okay.
Are all voter list are of Moiraja.
Mr. Sharma, we are giving an protection.
Yes.
So he has Sigdar land counsel for the petitioner. Full stop. Also heard Mr. M. Adhikari, CGC appearing for respondent number 1. And Mr. G. Sharma, and standing counsel for the Home Department representing respondent number 2 and 3. And Mr. R. Talukdar and the government advocate appearing for respondent number 4. And Ms. P. Barwal and standing counsel for respondent number 6. None appears on call for respondent number 5.
Let's file the dues.
Page 125, opinion. The opinion dated 2/11/2022, passed by so-and-so in so-and-so, arising out of reference REF, case number 5158/A, dated 1/98, is the said in this resolution filed under Article 226 of the Constitution of India. That the notice returnable in 4 weeks be issued. Requisite extra copies of the resolution be served on the its CGC, State and Departmental Council within 2 days. That the relevant records be requisitioned from the concerned tribunal. Next, the petitioner shall appear before the petitioner, namely Jarina, Jarina, Khatun, Khatun, shall appear before the Supreme Office within better Bangla. Borpeta. On furnishing a bail bond is 5,000. You got the conditions. Next, Peta. Even the petitioner does not appear before the Supreme Police within bracket border. Borpeta. The order of bail shall stand after effects of time. Next, list after 4 weeks on receipt of tribunal records. 10 days time to take bail.
Item 11.
May I please, your lordship?
Yes.
My lord, this is contested case, my lord. Lord, your lordship will find the opinion at page 64, my lord.
Page 54.
64, 64, my lord.
6.
You see
And what is
opinion?
the best document you have?
My lord, the documents, my lord, marriage certificate and Jamabandi copy.
Where is that? Where are those documents?
Marriage certificate at page 38, my lord.
38.
38. And my lord, yes, 38.
Which is not good. Yes.
Sanyara Khatun, my lord, daughter of Sorabali. Sorabali is the father.
And where is your land documents?
Land documents, my lord, at page 40. Oh. This is vernacular, my lord. My lord, page 42, serial number 24, my lord. Semlai Bewa, this her mother, and her name is, my lord, at page 44, serial number 45.
45.
44, page 44, serial number 45. Sanyara Khatun, mother Semlai Bewa, father Surabali.
Where is the remark?
Remarks at page 47, my lord. 47, my lord. Dated 11/5/2023, my lord. May I read, my lord, the vernacular part?
Just a moment. Where is the remark against serial number 24?
24, my lord. 24.
Post 71 lordship, when lordship,
My lord,
village is different lordship.
page 41, my lord. Page 41, remarks of, my lord, serial number 24. 11/1, 2011, my lord, dated. Semlai Bewa, bottom.
So this is the entry of 2010.
11, my lord. 11,
11/1/2010. This entry is made subsequently. So this land document doesn't show anything. Okay, we'll call for the tribunal. We'll leave some interpretation for some time. Mr. S.A. Ahmed, counsel for the petitioner. Sam Adhikari, CGC appearing for respondent number 1, Ms. P. Barwal, and it's standing for respondent number 2, Mr. G. Sharma, and it's standing for Home Department, representing respondent number 3 and 6. And Mr. R. Talukdar, the government advocate, appearing for respondent number 5. So none appears for respondent number 4. Page 64. The opinion dated 18/1/2024. Passed by the Foreigners Tribunal, Borpeta 11th, in case number so and so, page 65, arising out of PE number, IMDT case number so and so, page 65. Assailed in this petition under Article 226 of the Constitution of India. Save out of notice, bail, call for the records, extra copies. In the event this bail is to the satisfaction of Superintendent of Police within bracket border, Borpeta. It's been the petitioner fails to appear before the Superintendent of Police within bracket border, Borpeta, and take bail within the time allowed. The order of bail shall stand lapsed by fixed of time. Okay, continue post lunch.
Item 12.
There's no representation for the petition list after a week. All the respondents are represented.
13.
May I please, your lordship?
Yes, what is your explanation for coming after 2 years?
Financial hardship is the main problem.
Pardon me?
Financial hardship is the main problem, lordship.
And what is the best document to link you with your rejected
Yes, sir.
parents?
Lordship, there is a link document, lordship, and there is the Gaura certificate at page 34. And Gaura was examined, but he was not cross-examined, lordship. Gaura adduced evidence, and that is at page 51. He was not cross-examined.
Where is the opinion?
Opinion, lordship, page 54.
54.
Lordship. There is
And
no
where is the evidence of that Gambura?
Gaura, page 51, lordship.
51.
Yes, lordship. And there is no discussion regarding DW1 and DW2 in the impugned opinion, lordship.
Lordship.
Okay, we'll examine and yes, give him bail. That's right.
Lordship, may I leave for a moment? I'm feeling very uneasy, Lordship. May I leave for a moment, Lordship?
No, we are allowing, we are
Lordship.
giving a bail.
Okay.
Please, you can go.
Lordship.
You can leave.
Lordship.
Right.
16 days. Copy paste. Which is 60.
Meeting. It's okay. Okay, heard. Mr. M.I. Hussain, and counsel, the petitioner. Also heard Mr. M. Adhikari, Leonard. CGC appearing for respondent number 1. Mr. J. Payang, Leonard, standing person for the Home Department, representing respondent number 2 and
6, 7.
2, 6, and 7. Miss, you're not there?
So the copy, it's for another council. AIL, Your Honor, you can mark AIL.
Okay, Mr. A.I. Ali, Leonard, standing counsel for respondent number 3. And Mr. R. Talukdar, and a government advocate appearing for respondent number 5. So there is no representation from respondent number 4. Next paragraph. The opinion, page 54, the opinion dated 18/6/2022 as specified is assailed in this requisition filed under Article 226 of the Constitution of India, by which petitioner is declared to be a foreigner of post 25/3/1971 stream. Notice extra copies call for the records. Bail 5,000 to the satisfaction of Superintendent of Police Border Barpeta within 10 days. Just after 4 weeks on receipt of records of the tribunal. No representation, but list after.
May please your lordship. Well, here in this case, petitioner contest the proceeding. His father is voted in 1966. Father was examined, Gabra was examined, elder brother was
We are
examined.
coming after 6 years.
My lord, that is delay is there, my lord. We have explained in paragraph 15, my lord, my lord, women of remote shore area, my lord. We have explained in paragraph 25,
Page
page 27.
27.
My lord. Page 27, paragraph 25, my lord.
But your allegation is unacceptable. You have read your statement. Expenses and fees of the higher judiciary. We are only charging you 60, 50 or 60 rupees.
My lord, I'm sorry, my lord.
You see how
I should be careful to.
no,
wording this,
you should
my
also
lord.
think that you, since we respect
My
you,
lord,
we read
sometimes-
every word of yours.
My lord,
That
I'm
leads
sorry,
you
my
to difficulty.
my lord, I'm sorry, my lord.
Should be high and huge fees of the
My lord,
learned lawyer, not the higher judiciary.
my lord, yes, my lord, I admit our fault, my lord.
And what is your document, best document to
My lord,
connect?
documents, my lord, kindly have a look at my lord, page 42. Father's name is at in the voter list of 1966, Ramezuddin. My lord, father is all along voter, and father was also examined, my lord.
Where is your evidence?
My lord,
And where is your voter list of 60 and sorry, 66 and 70?
66, my lord, at page 42. Vernacular at page, next page 43, Ramezuddin, father. Then my lord, 70 voter list at page 44, Ramezuddin. Then my lord, 97 voter list. My lord, father
what
is
is-
continued to be voter.
And where is your father's evidence?
Father's evidence, lord, you will find at page, evidence in SIP at page 65.
55.
Yes, my lord. Cross examination for,
65.
yes, my lord, 65.
And the cross?
Cross at 69, my lord. The examination to court, my lord.
Okay. Mr. Pine, we are giving some protection. Yes. We are signal and counsel for the petitioner. Opinion is at which page?
My lord, evidence,
No, opinion.
opinion is, my lord, at page 78,
17,
78, my lord,
78.
annexure 19.
Opinion page 78. Opinion dated 3/11/2018, passed by so-and-so and so-and-so. Notice call for the records, extra copies. Bill is 5,000 to the satisfaction of
My lord,
Superintendent of Police
SPP
Borpeta.
Borpeta.
Borpeta. What's your respondents? You will write number 1. So M Adhikari for respondent number 1. CGC for respondent number 1. Mr. J. Pang, Donetsk Technicals from the Home Department, representing respondent number 2 and 6. Election Commission, you are there.
Yes.
Ms. P. Barwa, Donetsk Standing Counsel for respondent number 3. And Mr. R. Talukdar, Donetsk Government Advocate, appearing for respondent number 5. None appears for respondent number 4. Okay, bill 10 days.
My lord, deeply obliged.
May I please?
Yes.
My lord, contested case, my lord. My lord, the petitioner's younger brother, my lord, deposed as DW2, my lord. And name of petitioner and DW2, my lord, appeared in the Jamabandi Court in land accord. That is, my lord, at page 48.
Emerald. Motira Soni.
Home Department representing respondent number 3 and
6.
6. And Mr. R. Taludel, and a government advocate appearing for respondent number 5. Mr. Adam appears for respondent number 4. Page 71. Opinion dated 2023. Passed by so-and-so insurance. The notice call for the records. Extra copies within 2 days. To appear before the SP border hospital within 10 days. I think bail of is 5,000 with all those conditions. List out of 4 weeks on receipt of travelers records.
Obliging.
17.
Here also, Mr. Pine.
Yes.
You look at the cross-examination of DW3. You find which page is DW3? Page number?
DW2, my lord. DW2 page 67.
Hmm?
67, my lord. Seven. Original copy 69.
You've seen the cross?
Yes.
Item 17.
17.
May I please?
Yes. What is your best document?
Best document is Lordship's Exhibit 1. There is a case, CR case, that is page 32. My mother's, there is a separation, there is a dispute between my father and
Which page?
mother. Page 32, Lordships, and
32.
32. My father submitted a complaint against my maternal grandfather, my mother, regarding matrimonial dispute, Lordships. In the said case, my name is also written, Salimuddin, that is 1993. Now I am residing with my mother in my maternal.
No, that doesn't help because the reference was made earlier.
Reference notice was issued, Lordships, in 2000, notice, Lordships, 2016, I think, 93.
References of 94. Thereafter, you have filed this case. Any other document?
Then thereafter document 1966 of my grandfather and his brother, 1970 my grandfather, his brother, 1985 my father, mother, 1989 my father, mother, there is a sale deed exhibit 2 that is 25/3/1940 that I have not annexed lordship, but it was exhibit 2. And another Kotian exhibit 9, page 39, where also my father's name, grandfather's name, my maternal, my grandmother's name also appeared. Great grandfather's name also appeared, page 39. My name first time appeared in the 1997 brutal list where D was inserted.
Yeah, but this is not.
Page 39.
This is an exhibited document.
Lordship exhibited. All are exhibited. These are page 39. That's Kotian lordships. Brutal list 1966, 1970, 85, 1989. All are exhibited lordships. Serial number, page 39, serial number 9 is my great grandfather lordships. Serial number 11, my father's name. Serial number 2, my grandmother's name appeared. That is relating to exhibit 2. That exhibit 2 lordship here is not annexed lordships.
And in lecture 1, what is that?
Lordships.
Page 23 is an opinion. What is that?
Twenty-three.
This is 125 CRPC proceeding.
CRPC proceeding regarding there's a dispute between my father and mother. Thereafter, a maintenance case was also filed lordships. In this case, my mother's name mentioned as Joloi Bibi, and my name is also mentioned that Salimuddin. That is 1993. That is a document. And here, lordship, because separation, my mother now residing in his father's house lordship. I also residing with my mother lordships. And that document 1997 appeared in the brutal list of my maternal grandfather's house lordships. That's why exhibit 1 is related to the instant case lordships. And there is a evidence also in this regard lordship. There is a WS clarified also in this regard. Tribunal said that since my mother was separated from her husband, so why my name not appeared prior to that, why my name not appeared in the brutal list? But there is a brutal list appeared lordship 1985, 1989, my mother's name appeared also.
Okay. Right. Mr. F.U. Bob here, I counsel for the petitioner. Also heard Mr. M.R. Adhikari, CGC appearing for respondent number 1. Mr. J. Payal, I'm at standing counsel for the Home Department representing respondent number
2 and 6.
3. Sorry, 2 and 6. And Mr. Arthur, the government advocate appearing for respondent number 3. He, yeah, I have paid. Yeah.
No,
No, here three is deputy
Deputy
commissioner.
Commissioner.
Three. Three by Talukdar, four by Malad.
Four is by
Ali.
Mr. A. Ali, standing counsel for respondent 4. None appears on call, respondent 5. Opinion is at page 93. The opinion dated so and so, passed by so and so and so and so. We will settle in this regulation and Article 226 in the Constitution of India. Notice extra copies. Call for the records. To appear before Superintendent of Police within bracket border, bracket first Karimganj, within 10 days, bail rupees 5,000. This after 4 weeks on receipt of trial court record, of tribunal's records. 10 days to take bail.
10 days.
I'm being item 6.
My lordship, my lord.
What is the explanation of coming after 4 years?
After 4 years. Well, that lordship actually, she's a poor man and she could not manage money, and that discussion I have replied to your lordship the other day. But I have a very good case on merit. The 5 witnesses have examined.
No, but you need to give some explanation in the writ petition. There is none. No explanation in your writ petition of the delay. You have to file an affidavit, bring it on record. There must be something. Better bring some explanation on record. We'll take it up on Friday. By that, you will file it.
Fine.
Mr. M.U. Mahmood Ghanar, counsel for the petitioner. You say both sides are represented. Mr. M.U. Mahmood Ghanar, counsel for the petitioner. Yes, for has granted time to file an additional affidavit to bring on record the explanation for delay in approaching the court. Next paragraph, list on when?
Friday.
18th Friday.
Oh, Friday is a holiday, 18th. 18/11/2024.
Supply item 46 for motion.
Look in this case.
Yes.
The petitioner appeared before the tribunal and filed written statement. And also, she was examined as PW1.
What is your explanation for
She was
coming after a
also-
year?
She was also
What is your explanation of coming after a year?
I mentioned it on paragraph, my lord. Paragraph 7, 8, and 9, my lord.
Page
Paragraph 7.
17,
Paragraph 7, page 7.
7, page 7. Oh, that correspondence.
My lord.
Yes, Mr. Pine, can we give protection to petitioner?
No, I am in detention camp, my lord.
Oh, acha.
That is why record was called for. Here, my lord, I was examined. I was also thoroughly cross-examined. And I submitted one evidence on my brother. But he was not cross-examined. And that is why matter was proceeded expertise. Was kindly say impung order. He is instead of giving the finding on merit.
But your brother has a different name.
Na Shukur. One
No.
Shukur Ali of my brother. He was submitted his evidence in chief, but he could not
Well,
be,
there's some difference in the name of your brother.
my lord.
There's a difference in the name of your brother.
But he was not cross-examined.
No, but
That is why that was
no,
metaphor.
but there's a difference of name.
Shukur Khan,
Where is that?
page 54
54.
in evidence in CP file, but his evidence has been discarded because he was not cross-examined. Shukur Khan. And my one document,
Where is your statement about this name, difference of name?
my Rosal page 89.
59.
89 is a Jawandi copy. My father, after
No. Your brother,
What?
has he said anywhere that his name was different?
no, because he has not cross-examined, my lord. That is why he is not there, not appear.
No, it's not a question of cross-examination. Has he made a statement anywhere that his name is different in different voter list?
No point.
Because instead, what we find is that instead of saying that his name was different, in page 61, paragraph 31, he says that his name is so and so. Therefore, if he gives evidence of a document which is carrying a different name, his evidence was rightly rejected.
No, not rejected because he has not cross-examined. He has not appeared for cross-examination.
okay.
That is why.
That's okay, but it was rejected ultimately.
Ultimately, his evidence is not coming.
If his name doesn't match, how does he prove anything?
No, it is then my evidence is the learned member should have pronounced the judgment on merit on the basis of my evidence, my lord. The loss of is the judgment.
Where is your evidence?
Particular judgment, my lord. The loss of is the page 64 judgment.
Where is
The learned 64. The
where is
learned member,
your evidence?
my lord. My evidence is, my lord. Page 26, my lord, written statement. That is.
Page
Page 26 is a written statement.
26.
Yes, my lord.
26 is a written statement.
Yes,
or
evidence is, my lord, page 41. Paragraph 24 of my written statement.
Mr. Payne,
Well,
you're releasing him on bail. You see, the opinion doesn't say anything.
record is here, my lord. Record was called for my.
Because we call for it has not come, but we gave a short notice.
Yes.
No, records are with you.
Yes, record is with me.
Just can I see that for a moment?
Evidence.
Okay. Is there any interlocutory application for bail?
No, my lord. Because the matter was proposed to dispose of finally, that is why. Matter was proposed to dispose of finally since there is a detention camp.
No, we have never issued a notice. Could not have been
Notice
disposed
not
of.
issued, my lord. Just my friend was asked to bring their records on for their own. Short notice may be issued, my lord. Certainly, record is.
No, Mr. J. Ahmed, land counsel for the petitioner. Also heard Mr. M.R. Adhikari, learned CLC appearing for respondent number 1. Mr. J. Payang, learned standing counsel for the Home Department representing respondent number
2, 6, and 7.
2, 6, and 7. And Mr. A.I. Adil, standing counsel for respondent number 3. And Mr. R. Talgar, government advocate appearing for respondent number 5. There is no representation from respondent number 4. Next panel. The opinion dated 1/3/2023 is page 64. Passed by so and so insurance. Is assailed in this writ petition filed under Article 226 of the Constitution of India. Issue notice returnable in 4 weeks. So requisite extra copies of the writ petition be served on the learned CGC, State and Departmental Council within 2 days. Next, with the next pursuant to order dated 23/9/2024, the learned standing counsel for the Home Department has produced the records of FT case number 497 of 2018. So peruse the same. Next, I heard both sides of the prayer made by the learned counsel for the petitioner for releasing the petitioner from detention center.
Matia Walpara.
Matia Walpara, which is proposed by the learned standing counsel for the Home Department. On the ground that the petitioner is a D voter, and despite the rendition of opinion dated 1/3/2023 by the learned tribunal, petitioner did not assail the same. Next paragraph. On the result of the records, it appears that the petitioner has exhibited nine exhibits. 9, no, not 9, 10 exhibits. No, not 10, 11. 11 exhibits. But the learned tribunal has not discussed any of the exhibits. We also take note of the fact that the petitioner appeared in the proceedings before the learned foreigners tribunal as DW1, and she was also cross-examined. On 9/5/2022, the learned tribunal appears to have proceeded ex parte against the petitioner stop. Under the circumstances, cover the matter is required to be heard. Next paragraph. Considering the position of the petitioner that she is 66 years of age, court is inclined to direct that the petitioner will be released from the detention camp, Matia, Gwalpara, subject to conditions below. Next paragraph. The family members of the petitioner shall produce a certified copy of this order and also furnish a bail bond shall appear before the Superintendent of Police border Bopeta and furnish a bail bond of rupees 5,000. And on furnishing of the bail bond, bail bond, not bail bond and a certified copy of the order, the Superintendent of Police within bracket border, Bopeta, shall secure the release of the petitioner, namely Mariam Bewa, the page 2 was spelling, alias Mariam Khatun, in his custody, in its custody, and the city authority take the fingerprints of both hands of this iris and all, huh? And shall also take the usual undertaking for appeals as and when required, and thereafter release the petitioner on bail. Next one, as a condition of bail, the petitioner is directed not to leave the jurisdiction of the Superintendent of Police within bracket border Bopeta without prior written intimation to the said authority. Next paragraph. This Mr. Bai, this tribunal records what to do about it. It will be in your custody.
My lord, if your lordship may keep it in the custody of court, my lord, and only may be recorded that it is in our custody. That may be recorded.
No. Next paragraph. It may mention that the learned standing counsel for the Home Department has handed over the custody of the records of FT case number 497 of 2018. So this will be kept as a part of record. The AOJ of the AOJ within bracket FT matters shall record the receipt of the concerned tribunal in the note sheet and make it a part of record. Next paragraph. List the matter after 4 weeks on a date to be fixed by the registry. Entry code.
Hello.
Supply item 47.
Please, your lordship, the person is in detention.
Yes.
Page 37. This is the LVO report. Let's kindly come to page, the type, the original is at page 42.
What is the explanation of coming after 3 years?
It's a pro bono case and it's poverty, because of poverty, the client was not able to reach out. It is only after he was detained that some of the lawyers advised him, from his villages, that there are people at Guwahati who takes up these cases. And that's the reason he approached us before your lordship.
This is from Borpeta district. What happened, last, even after declaration of huge number of foreigners, they did not approach the Honorable Court. Only in the October, some 29 such persons has been detained by the Borpeta police. Then only they are coming. Now, if your lordship will see, almost all the cases are from Borpeta district. Now, only after detaining them, they are approaching before the Honorable Court after 3-4 years, madam. There is no bona fide at all, madam. They were hiding, and when they have been detained, they are now approaching the Honorable Court.
I have a good case on merits.
Merit, I'm not on merit at this stage, but that is the condition, madam. Otherwise, they were hiding for last 3-4 years.
There is no allegation in the, may I submit your lordship?
When we taken into custody,
7/8/2024.
7,
8,
2024.
24. Yes. May I request just one thing? There is no allegation in the LVO report. LVO report itself says that I am an Indian citizen. At page 42.
Yes.
Page 42. Page 42, your lords. Kadir Pramanik, Satkarna, then 1490, date of father's name, Makboy Ali, date of birth 1960, place of birth, Soyatpur. Then at the verification, they asked me for my for linkage. I submit them 1966 voter list of my father, and then second page, mother tongue Assamese certified extract 1966. I submit before them. Then your lordship, date of his days, the 60 column 16, the entire column is blank, on which date I have entered. Then let's kindly come to page 45, which is a very important, that's an observation by the MBO, which itself says that the father, I'm, uh, I'm is enrolled in the 66 voter list of village Soyatpur as per the voter list so and so. It's in Assamese. I'm reading the translated portion. Original. Yes, sir. পত্র দিয়ে এই যে কাদের প্রামাণিক আলীগাঁও সৎকর্ণা গোবিন্দপুর রিজার্ভ সো এন্ড সো থানা বাগবই জিলা বৰপেটা উক্ত মানুহজনৰ পিতাকৰ নাম 1964 চনৰ ভোটৰ তালিকাত দিয়ৰ উক্ত গাঁৱত নামত থকা দেখা যায় ভোটৰ তালিকাত মতে ঘৰৰ নম্বৰ 69 অংকৰ নম্বৰ 224 so and so গাঁৱত বিধানসভা সমষ্টি বাগবই বিধানসভা সমষ্টি. So, and even in the notice, I have also annexed the notice. In notice, it's completely vague. The law is very clear that for them to refer a notice, they must click on the stream of foreigner in which the allegation of which I am being alleged. And on the law, your lordship, the recent judgment of the Honorable Supreme Court in Rahamali is very clear. The proceeding itself is illegal. Rahamali, your lordship, I have mailed the copy. It's in the, may I cite the paragraph 33, 34, 35, and 36. May I cite 2024 INSC 511 is the citation, independent citation.
Yes. My lord, if your lordship directs, it will get, my lord. No issue. By 2 weeks, we may get the record. Rahim Ali, my lord, yes, my lord, Rahim Ali has said something about the notice, my lord. Notice, but my lord, here, whether that notice is not cited exactly, my lord, what was there in the notice contents, but here the, yes.
DK Agarwal. DK Agarwal. I am on it. DK Agarwal. Which page is that? Which page is the opinion? Opinion 33. There are two opinions. One is the opinion, then there we have filed a review. So the opinion is at page 33, the review opinion is at page 90. Review 100 plus. 811. As well as other defect. 1924. This review petition was not separately numbered. It has been registered as miscellaneous application. It has been registered as miscellaneous application number. Here is a page 110. Miscellaneous case number 01/2000. This case number 1 of 2024. Which is a review.
Bhavita. Next, whether the registry is at liberty to send requisition through email requiring the Foreigners Tribunal, 4th Bhavita, to send scanned copy of the records of FE case number 74 of 2018 in the event the records cannot be physically transmitted to this court. Post of the requisition shall be sent to the following email address of the tribunal. Mr. Pang, please give the email address of the tribunal.
Yes.
Leave that a gap, they will give it. Next one. Sure. When we say issue notice, also say issue notice, including notice in IA Civil 3431 of 2024. Last panel. The clear made in the interrogatory application shall be considered on the next date of listing. Next list on 29/11/2024.
One question, my lord, one thing, my lord. As I have seen, there is no explanation about delay. My lord, so maintainability may be kept open, my lord. What?
He's given that there is a pro bono lawyer, and then that is the explanation.
There is no explanation.
That is the only explanation, that he is poor and could not afford a lawyer.
Which good prayer? Five zero.
That is the first question we asked.
Yes.
Even at 25th, 29 is too late. 25th.
Because they'll have to scan it and bring it. The tribunals don't have the facility to do it. So just add that when I said that scan copy, say if the scanning facility is not available in the learned foreigners tribunal, come on, it may seek assistance of the office of the superintendent of police within bracket border, which place
Borpeta.
Borpeta, to scan the records and to transmit it by email.
Item 20 for admission. 20.
Yes.
In this case, the present petitioner challenged the impugned order, and thereafter the present petitioner also filed a review petition. It was not accepted by the learned tribunal, where some vital documents required to be filled. The earlier in the proceedings, the Gaura of the concerned village submitted deposition in favor of the petitioner, but there in the on the certificate, state emblem was there. So their certificate was rejected. So the present petition and the concert certificate also was not. And the school certificate which was partly damaged due to overflood. So it was also not annexed. So thereafter, after passing the judgment, proceeding filed a review petition, it was not accepted. And thereafter, after getting the certified copy, some anomalies regarding the investigation was appeared, and therefore the present petition also challenged the impugned investigation done by the concerned IOU lordship.
After opinion of the tribunal, you will not go back.
Fine. Lordship at page 81, the review petition was filed.
গুচি গ'ল নি? তিনটা কপি ললে ভাল, এটা আমার এটা দুজন যাবে। হ'ব থাক দিয়ক।
Lordship, matter may kindly fix.
Where is the evidence of Gaura?
Evidence that Gaura reports in case.
Did you examine him?
That page 63 words.
Page
63. 63. Here is the certificate and deposition part is 65. And is that 50? 65.
Where is the document?
Let's see your lordship. List of 1966 may kindly peruse that page 29. 29 in the. Where the name of the father and two grandmothers.
Just a moment. Where is the opinion? Which page?
Page 69.
69.
My. Translated for type of this.
Where is the review order?
Uh, 81 in portion.
No, 81 is a review petition. They are asking you where is the order?
Order, your lordship, the review petition was filed, neither it was allowed nor accepted. So the proceeding was filed, therefore it was challenged before the honorable court. The review petition was filed, but not even it was accepted. In the review petition, some regarding the purported investigation, some allegation or some objection has arisen, your lordship, and the proceeding therefore after getting the certified copy from the learned tribunal and gone through the records thereafter some purported investigation, the report has prepared without verifying the field level inquiry. And two witness was shown in the inquiry report of the border police. One was Gabura and one was a independent witness. Both the independent witness has given the affidavit that never I was appeared, never the investigation was conducted. So he denied, and Gabura also denied, my lord. And your lordship may kindly peruse that page 97. The notice and the bail bond was submitted by the husband of the OP. These all the proceedings are unknown by my lord. So your lordship, the here.
You see, you are saying that you went to the tribunal to prove to file a review petition.
Review petition.
You see, the review petition is at page 81. Correct. Now it does not. The page 87 is the affidavit is not even sworn. So how should we? Why should we believe?
In review petition, your lordship.
Yes, come to page 87. Your affidavit is not sworn. So why should we accept your statement that you went to the tribunal to file an affidavit, to file a review petition?
On 22nd of October 2019, it was filed.
You have heard us. You see, we are asking you or showing for the third time. Page 87 is your affidavit, and that affidavit is not sworn. So why should we accept your statement that you went to the tribunal to file a review petition? You can't go to tribunal and file a petition without any affidavit being sworn.
The original copy there is not.
And secondly, review must be filed within 30 days.
My lord, or time was over.
There's no application for condoning the delay.
Have mentioned the delay, my lord, at page 85, paragraph number 11, my lord, it has stated, my lord. 7 days is.
Try to understand, we are telling you something, respond to that. When the matter is barred by limitation, you have to file a section 5 application
Fine.
for condoning the delay.
Fine.
You have not filed any such application.
Fine.
Then even in our court, the review, without the condone, delay being condoned, we don't register many cases. It is merely shown as a filing number.
Separately, condonation of delay petition was not.
It was not there.
Paragraph 11, it has categorically stated, my lord, but review petition is not filed. So, sorry, condonation of delay petition. is
Not filed. It's as good as none. Now, in this, in your documents exhibited,
My lord. Considering
you have exhibited only documents A to F. Now, Gambura gave an evidence.
my lord,
That evidence cannot help you in any manner.
my concern here is that in lordship, the present petitioner has sufficient documents, my lord, to prove the case. If your lordship kindly consider the case, rightly or wrongly, some mistake has done, my lord, in the review petition. Considering the facts of the case regarding the documents, my lord, kindly if the honorable court allow to re-adjudicate the case and back the to the.
No, you have to show us that we have the power to do it. You have to show that we have the power to do it. Because merely because you have a document does not make you entitled to a writ of certiorari unless you satisfy the court.
Accordingly, the Gaugura certificate was issued by the Gaugura. There was a state emblem. So that's why it is correctly, my lord, but it affects the proceeding, my lord. So the consent certificate, Gaugura certificate, and one his school document, which was very old document and partly it was damaged. So all the documents kindly may allow to prove, my lord, for the interest of the citizen.
You see, your father came and deposed. He could not link himself to his father, to his own father. They were not together in any voter list. So there's a disconnect between your father and your grandfather. And similarly, he says that you also, after marriage, shifted to another village.
My lord.
So therefore, there's a disconnect between you and your father. Therefore, the only link is Gambura certificate. The evidence of Gambura, look at it, doesn't show anything.
My lord, that is why the issue has arisen, my lord. The basically to link directly to prove the linkage, my lord, there is no any document because neither the birth certificate nor school certificate. And after marriage, her name has appeared with her husband. So there is some problems regarding the women's section. It is due to not submitted the documents, my lord. Yeah, there is some gaps. But 66 to up to date documents has submitted, my lord. So one opportunity may kindly happen. From 66 to updated those voter list, the voter list, my lord, linkage has established. But the deposition of Gaura and Consent precedents is required. And due to one shifting was there due to erosion of their residence by the river Brahmaputra. They were shifted from one village to another place. School documents is also very important point. After class 4 level,
Which document?
in the school document, worksheet. At page 93 notes, and exactly. Kindly may peruse at page 93. Above right part was.
You see, you'll have to demonstrate that despite due diligence, those documents could not be filed. There is no explanation to due diligence. Exercise of due diligence is not there, not even pleaded. You see, there's a damaged document. But still you have not proved it.
It was not.
You have not called the witnesses to prove that. So
In the original case, at the time of evidence in CP, it was not exhibited by the engaged counsel,
oh, engaged counsel never will do anything.
my lord. But therefore, with the review petition, that document was submitted, my lord. So
You see, you are filing your evidence. You are signing it, you are swearing the affidavit. You did not see that those documents are not there. And there was no complaint against the lawyer that he was handed over. You filed your written statement. In your written statement, was it there? Those documents, are those referred to? No. So therefore, you can't blame the lawyer unless you bring evidence to show that you handed over those documents to your lawyer and he did not.
my lord, because the documents, though the procedure was submitted to the council, my lord, but it
No,
was
don't make that allegation. You see, you filed your written statement.
written statement, it was not stated, my lord.
It's not stated. Then where is a proof of that you gave documents to your lawyer? That's not there. You have not filed any complaint against the lawyer in the bar council that he took the documents and did not annex.
the proceeding my lord want to prove basically the Gaugura certificate. There was state emblem, so proceeding has no any knowledge actually regarding this certificate, but the honorable learned tribunal was rejected. It is as per law, it was rejected, my lord. But this certificate also affected the proceeding, and there is one conscience certificate, and if the opportunity kindly may allow, this school certificate may also to prove, give the opportunity to prove before the learned on any condition in lordship. Otherwise, in lordship, the proceeding will suffer.
We don't know whether in great petition we can show that amount of kindness.
Linkage documents, my lord, up to the voter list is here to prove the
They are not one. There are several judgments which says that voter list is not either a proof of parentage nor it's a proof of citizenship.
Gaugura, deposition of the Gaugura and the proof of the certificate, my lord. It is also required, my lord. But the Gaugura had no knowledge regarding the
You see, you must, there's also a gap. I forget the consequence, the connection. In some document, you say that your name is Aimona Khatun. In some document, it is written as Aimona Begum. Now, the tribunal arrived at a finding that in one document, you were born in 1947. And as per the other document, you are born in 1997. So 47 and 97 is 50 years. So how do you explain that discrepancy?
There is basically no such discrepancy has shown in against the proceeding. And the proceeding was become voter in the year 1997, first establishment. And that year itself, he was.
But then the other Aimona, she's a voter in, she's born in 1947.
All the things regarding the name and age, my lord. So one opportunity may kindly granted, because the regarding the present proceeding, my lord, there is no such age and name discrepancies. Sure. And father's name has correctly shown, grandfather's name has correctly shown from 1966 to up to date total list. Father's name and grandfather's name, and all the link has established, and deposition from the fathers, it has clearly proved that the proceed is the daughter of his father, and the Gaugura deposition also proved the linkage, but due to the state emblem, it was rejected. My Gaugura had no knowledge, and the proceeding had no knowledge regarding the issue that state emblem will affect the proceeding. So Gaugura is statement of the Gaugura deposition, it is very vital in lordship.
You are relying on case law? Are you relying on case law?
Yeah, I have not relied on.
Yes, Mr. Payeng.
It's on statutory jurisdiction, we have numbers of judgment, my lord.
One or two.
In fact, my lord, the deposition of the Gaugura has destroyed the entire case, my lord. My learned friend is, the deposition, Gaugura has, my lord, no knowledge at all. It's from the deposition, it is clear. And other the school, my lord, certificate which my friend is relying, that was not exhibited, and that was not proved. The next Panchat certificate, it was not proved, though it was annexed, my lord. And then, but the only document was that, my lord, the what they were trying to prove was the Gaugura certificate. as link certificate. The Gaubra has clearly said he has no knowledge where the petitioner was born. And so in absence of link documents and link the tribunal has committed no wrong in passing this opinion,
That's all.
Yes. And with regard to certiorari jurisdiction, this is 2023. Same judgment, no? The Honorable Apex Court recently, in 2023, discussed the only earlier judgments almost in this is 2023 23 SCC online 996 SCC online SC 996 and in that case from para 50 onwards, in which cases the Honorable Court may exercise certiorari jurisdiction. That has been detailed discussion.
Para 50.
Yes, 50 onwards, detailed discussion is met, and in fact, in case of our case, para 112 of the Muslim Mandal case has clearly said in which cases this Honorable Court may exercise under certiorari jurisdiction.
Okay.
Muslim Mandal 2013 1 GLT 809.
Muslim Mandal.
Yes, para 112.
What is the edition? 2000?
2013 1 GLT 809. Para 112, 112 and 113, clearly said in which cases this Honorable Court may exercise certiorari jurisdiction in foreigners tribunal cases specifically. So those two cases will cover
Okay, we'll pass orders in chambers. No, we'll pass orders in chambers. You do whatever you want. You have time till 4:30.
Another judgment of this Honorable Court 2021 1 GLT 799, 2021 1 GLT 799.
What is the name of the parties?
That is Nilvan versus Union of India. Nilvan, NILVAN. Nilvan. There, the documents, whether this Honorable Court accept documents at the certiorari jurisdiction, especially in foreigners tribunal case. Para 13, 14 in that case. That's enough. The Supreme Court judgment had been mailed to my court master. The essay.
Kindly be allowed for 2 minutes, my.
Yes, yes.
My lord, at page 99, in lordship of the petition may kindly pay. In 2024, I may allow to submit the Supreme Court recent judgment has given that the proceeding has to even reply on the reasonable and uh, proper investigation, my lord. If the investigation is proper and false, that burden will not lies upon the proceeding, my lord. Kindly may peruse that page 99, lordship. And vernacular page
99, yes.
100, my lord. May I read, my lord?
Yes.
I will read particular, my lord, please, or translated copy 99 page. Here the deposition has taken by the concerned IO of the proceeding, my lord, but the proceeding's signature is not there, my lord. And next, your lordship at page next page 101, my lord. Here the deposition has taken of the Gaura, my lord, but the Gaura signature is not there, my lord. And next, your lordship may kindly peruse at page the Siddiq Ali, the independent witness. In presence of the witness, the concerned IO has shown that the investigation was conducted on field level inquiry, but the independent witness, he has denied the investigation, where he has given the evidence affidavit at page 120 of the affidavit. Gaura also denied, and the independent witness, that is the whole investigation is purported and baseless, my lord. And the another, I am showing the record, my lord. Petitioner also challenged the purported investigation, which never had done, my lord. The present petitioner, he kept his signature, nowhere given his thumb impression. But here in the notice shown thumb impression, and every statement there is no any signature. So it is statement is totally baseless, my lord. If a person appeared and keep his statement, he should have put his signature, my lord. So I may kindly allow to submit my one Supreme Court judgment, my lord, regarding this issue, my lord. But I have not carried the judgment, my lord. Sometimes sometimes may kindly given. I will give it, my lord. Wait a second. So my respectful submission is that if the investigation is purported, my lord, so whole system is my lord against the proceeding, and proceeding burden 69 of the Foreigners Act will lies upon the proceeding when the investigation itself is proper and reasonable and lawful, my lord. If the illegal and unlawful investigation is conducted by the concerned IO, the burden does not lies upon the proceeding, my lord. That is my respectable submission. The Lordship permit me tomorrow, I will submit the.
Tomorrow would be too late.
Yeah, actually, my.
Saying that we'll pass the orders in the chambers. We have to rise for the single bench.
Itself,
Give it, take it out.
problem.
Yes.
Lordship, ever respond. With regard to item number 1 and 2, Lordship, we have submitted the written objection. Lordship, may kindly see the objection of the CBI. Most particularly page 28, paras E, Lordship. Lordship.
Lordship, in this matter, the petitioners are members of an NGO and they were operating in the name of Bullseye, which is a registered NGO, and the registration certificate is annexed. It is in Annexure B, page number 17, Annexure B. So it is a registered cooperative society under the registration of cooperative societies. Now, in this particular FIR, it has been alleged that this Bullseye was operating as a non-banking financial company and it was not registered. So from the fact that Annexure B reveals that it is a registered non-governmental organization in the name of Bullseye. In the FIR, it is stated that Bullseye, this particular organization was involved in luring the investors by these members, which included these accused petitioners as well as two other already two others. One is Kaishya Fukon, who had already been enlarged by this honorable court by order dated 8/10/2024, which is annexed as Annexure C. That is from page number 18 to 21. So going through the order dated passed by this honorable court, it reveals that from the case diary at that time, there was no material which shows that there was any sort of investors depositing any money to these members. So on the basis of that, the allegations that have been leveled against these accused petitioners regarding that they are involved in unregulated deposit scheme act does not have a footing as of now, because of the fact that there is no iota of a whisper against these petitioners by any individual investor. The entire FIR has been lodged on suo motu by the OCO of Nagaon on the basis of the information which has been got from some sources. Now, these particular petitioners, they are young people, they are unemployed youths. Recently, they have registered their companies, these non-governmental organizations as per the rules, and they were executing some societal works. Now, what has happened is that due to the onset of the different trading schemes and due to the pressure that has come upon the police, it might have been a case where these petitioners' name might have been probed by somebody on suspicion. But actually, now these petitioners, they want to come out and they want to participate in the entire ongoing investigation because of the fact that they are now hiding since last 1.5 months after the lookout notice was issued against them. Now, they wanted to come out, but since they apprehend imminent arrest because of the pressure that has been faced by the police department, now these petitioners, they pray before this honorable court to at least come out of their hideouts and then present themselves before the concerned investigating officer of the CBI, and they will cooperate with the investigation. They will record their statement. Whatever documents are required, they will produce it. Only fact is that they require the protection. No coercive action should be taken against them because these are youngsters and they do not have any past criminal antecedents as such, Your Lordship. So, and of the fact that since one of them has been also enlarged on bail on the order passed by this honorable court on 8/10, his name has been stated as a primary accused, which it shows that these members were operating under him and as agents.
That you have not collected any money from the public. Is there any statement made here that no money was collected?
Yes, in the bail application, it was there.
Where is it?
Lordship. paragraph 7 in my bail application 2869. Page number 6, paragraph 7. There they have stated that the accused petitioners beg to state that, as mentioned in the FIR, Bullseye is not a non-banking financial company. Rather, it is a registered NGO in the name of Bullseye's Foundation. The same NGO has been established by the accused persons along with few other respected individuals of Noga for ambulance services, for carrying out various community services like providing ambulance services and others. That the registered NGO nor its members have ever been involved in commission of any act, thereby attracting customers by way of false promise of high returns on deposits. Rather, the NGO has been established solely for the purpose of executing various societal lordship. So it shows that they are not involved with the commission of the offense as stated in the FIR. Because regarding the unregulated banning of the unregulated deposit scheme act, 3 ingredients are required. Number 1, soliciting deposits, then taking deposits, and then finally fraudulently not paying the returns on the deposits. So this, for all these ingredients to be satisfied, there has to be a prima facie case that these particular individuals were involved in receiving money and then again utilizing them from their accounts, and then finally for their own misappropriating the fund which has been gathered. But now the entire particular fact that they are involved in taking deposits does not arise at this point of time, and it is a matter of investigation. So as of now, they want to come out because they are young people, their families are suffering, my lord. They do not come from very good financial background. They are mainly involved with Bullseye Foundation as an NGO, and they were working on the pretext of carrying out the societal works. Now, what has happened, Lordship, is that suddenly the police started looking after the lodging of the FIR on 3/9 because of the pressure police has also got from the number of cases that has been registered on the pretext of trading schemes. So, praying before the Lordship that as of now, at least they should be given protection and they will come out. Stringent of
Who's there? Who's in the next matter?
1 and 2.
1 and 2 is yours.
Yes, sir.
Your name is?
2869 and 2871.
Your name?
WRB.
WRB.
4 accused petitioners are here in 1 and 2. They are fine.
Yes. In third matter.
Let's see what was the outcome of the preliminary inquiry.
Yes.
Yes, ma'am. Here, start from page 11, that the company was not registered in a regulated body. Page 12, what you find that they were offering high interest or returns to new customers. The number, page 12. Those that preliminary inquiry matter done by the Assam police prior to the registration of the FIR. So there was an apprehension that investors are unaware of where their money is being invested. Number 3, which is seen. Number 4, there is high risk of losing the principal amount or expected return. And 5 is there is no protection or recourse for investors in case of default. So primarily those were the grounds, or rather the apprehension of the investigating agency at that point of time, that finally that what will happen to the investors' money. So now, madam, if your lordship goes to the objection, madam, filed by the present investigating agency, madam, where, madam, page 21, madam. Now, one line is there that some amount, madam, one check was found, madam, one check was found in the residence of the present petitioner. So whether that amount, whether it is a normal course of business or for what purpose. And secondly, that 7, the banking transaction, of huge amount, that was found,
in the account of the basic petitioner from 1/4/2024. Those are the two matter. Primary litigation against him matter. And para 9 you should see that the mobile phones were and the act of words seized where seized matter, whether it is his or not, that argument, it is the objection. And the most importantly, what you kindly have to look at page 22 matter, affidavit matter. The parawise reply B matter. B matter. Last 4 lines matter. And I read it matter.
Yes.
Yes. Thus, the investigation has revealed that the accused petitioner in the name of so has been fraudulently running under the deposit scheme and had cheated several people which are yet to be ascertained. Kindly see it. Hereafter, my lord, next page, my lord. Page 23, my lord. There is one line that the IO of Nova Pierce has obtained the bank account statements of the accused person and it is revealed that the accused have been receiving money from several accounts. Thereafter, it's important, madam. However, most of these transactions are done through UPI, IMPS, and thus further details are awaited. The details of all the depositors, investors are yet to be identified and thus CBI needs further time for thorough investigation of the case. And F also, my lord. F not, we kindly see the last line, my lord. Page 23, and have cheated several people which are yet to be ascertained. And my lord, why the bail, anticipatory bail here is being objected, that lord should find. Page 23, G, my lord. Here lord should find that primarily they think that my lord, he may flee. Again, he may influence important witnesses, my lord. And if he is released, my lord, you will have access to online trading accounts and siphon of depositors' money. Actually, since my lord, that account has been, my lord, already seen by them and possibly it has been frozen by the time. That account money. And here, my lord, again, last line, if he is released on bail, he may conceive himself and siphon of the depositors' money. And use financial clout to win over intimate the witnesses. So those things, my lord, it will lordship that earlier order lordship pass the direction, although bail was granted, but they are subject to the condition that if they found something, they can come for cancellation. And even those apprehension, my lord, that can be possibly with stringent conditions, my lord. Because on apprehension that he will flee or he will influence the witnesses, then my lord, he will conceal, intimidate, and he may go for, my lord, those things, my lord, that can be taken possibly through stringent, my lord, conditions. And since mobile phone desktop already seized and my lord, bank account already possibly frozen, my lord, subject to what my planet colleague states, my lord. So possibly here absolutely on, although my lord, parity, my lord, has to be possibly same footing with my limited, my lord, that subject to what is there with your logic, my lord, parity possibly remains. And here, my lord, another aspect what we have seen. my
You have the case diary also?
Lordship, I have received the case diary.
Can I see?
They are saying that let him complete. But the initial the investigation, my lord, the first FIR was lodged on 3/9/2024. Those dates, my lord, because now, my lord, it is around, my lord, more than 2.5, nearly more than 2 months. When your lordship passed the earlier order, it was on 8/10/2024, my lord. Then it was around 35 days, my lord, of investigation. And now after taking over of investigation by the CBI, it is around 22 days of investigation. All of it.
Yes.
Other circumstances, if they had siphoned of money or they have not returned the amount, if they have promised high returns, all these depositors possibly would have come before the agency to make a complaint against them. Here possibly on last occasion when the lordship went to the diary so there were no depositor as such at that point of time. Now from the affidavit also possibly the same scenario. Those they've got ample time to investigate. And here possibly I may be wrong, subject to your lordship's understanding. Here, this unregulated because here they have stated this is on online trading. Online trading itself, it is not possibly illegal. It's illegal. But so, if it is a regulated, they have not premised any scheme or sort of like that, They are trading, So trading, for that, regulated deposit scheme, there is a different offense altogether, That 22 possibly, that is a bailable offense. If it is a regulated deposit, if it is under the regulated deposit scheme, that Lord should find section 4, there it states no
Section 4 of
this Bath Act,
Hmm?
banning of unregulated deposit scheme act, There it states about punishment for promising and thereafter not misleading and false deceptive of that nature in any I'm sorry, that is, yes, section 4, No depositor while accepting deposit pursuant to a regulated deposit scheme shall commit any fraudulent default in repayment or return. of
Okay,
deposit.
just a moment. If you have to say more, I have to give it tomorrow because I have to rise. There's a
Lordship have already seen the diary.
There's a-
And the objection itself makes it clear that there is no, that those,
I'm assigned with some administrative work.
those only,
Okay.
Those only, those. And the act itself, Lordship may see, their mechanism.
Going to conclude it today, Lordship? Or some other?
No, tomorrow then. Tomorrow. Because 4:15 I have
Lordship.
Submissions of the learned counsel for the petitioners is concluded. So, Mr. M. Haloy, Leonard, standing counsel for
Special
the
PP, Lordship.
special PP for the CBI has filed an objection in this matters which is made a part of the court and is also ready with the case diary. Expected to paucity of time, the non special PP for the CBI could not be heard. List on
We may give a short reply also after.
We return you your case diary.
You cannot because it's just from Shillong.
We are returning you the case diary.
Yes, yes, yes. Also, one more difficulty is, Your Lordship, the case is handled by Shillong branch. Again, they'll have to take back the case diary to Shillong. Tomorrow again, they will have to come. Can it be after 1 week, Lordship? Because investigation is also going on. If we hamper the investigation, we
No, you ask them to be tomorrow here.
tomorrow.
You return it. Unnecessary traveling with the case diary would be more difficult.
I'll ask them to stay, make a stay. I'll ask them to make a stay. Difficult. It's anticipatory bill, let it be fixed after 1 week. Lordship.
It's just
AB,
consumer, it's a
It's not
anticipated
AB.
matter and he is
It's an
asking for
AB.
1 week there. How can it be managed?
Those bail matters to keep it. So long is also not advisable.
It never stated anything more from day
If
one.
not tomorrow, then day after tomorrow.
I think after demand record.
Or you can do something, you can keep the relevant pages of the case diary here, photocopy, retain it for production before the court.
Lordship sees the case diary. Lordship investigation is going on. I have seen. And only
Oh,
the
that's okay. I don't have time because
Lordship,
there are persons waiting for the meeting.
Lordship. Let it be on Lordship then the 18 Lordship. 18 Lordship.
18th is 1 week.
1 week Lordship.
No.
14 Lordship lot. This
14?
is very exhaustive. Lordship. 14.
Okay, then make it 14th.
14 no Lordship.
14,
14 will be very difficult. Lot of cases are already listed on 14. Huge number of cases.
you can't help it.
Let it be on 13 Lordship.
13th,
13th.
okay. 13th? No, don't even. 13th. His diary produced is returned. Will be produced on the next day to Wednesday.